Welcome once again to Lehto's Law. Here's Steve Lehto.
I was talking the other day about juries and judges and who decides what in a courtroom in the context of why jurors cannot ask questions or why judges don't ask questions directly of witnesses. Why do they let the attorneys do it? And somebody asked, and it's an interesting question, somebody said, well, doesn't the Supreme Court conduct trials? And it's an interesting question because they actually do occasionally, but it's very, very uncommon. But generally speaking, you hear about the Supreme Court hearing cases on appeal. And we talk about trial courts. I've talked about trial courts before. So in Michigan, for instance, if you are a landlord and you want to sue a tenant and get the tenant kicked out, you take a landlord-tenant action and file it in a local district court. On the other hand, if somebody wants to get a divorce, okay, that gets filed in a circuit court. And those are courts where they conduct trials, and those are trial courts. And of course, you've heard that if something happens at a trial and it goes up on appeal, there's appellate courts. So you've got these lower level trial courts, and then you got appellate courts. And some states then have a Supreme Court overseeing a layer of appellate courts. Appellate courts hear what comes up from the trial courts. And the interesting question is, do these upper level courts ever actually conduct trials? Or are they always simply hearing things on appeal? And the answer to that, of course, is that there are rare occasions where the Supreme Court gets to sit as a trial court. It just doesn't happen very often. So we'll talk about this. And I got this information directly from the Supreme Court's website because they actually have a very good explanation of it. But it comes from Article 3 of the Constitution. So again, we've been learning a lot about the Constitution on this channel. Article 1 describes Congress. Article 2 describes the president. Article 3 describes the courts, okay? And at the top of the court system is the Supreme Court. So Article 3 of the Constitution establishes the federal judiciary. Article 3, Section 1 states that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. So in other words, Congress gets to establish other courts that would operate directly underneath the Supreme Court. Although the Constitution establishes the Supreme Court, it permits Congress to decide how to organize the courts. Congress first exercised this power in the Judiciary Act of 1789. This act created a Supreme Court with 6 justices. It also established the lower federal court system. And some of that's changed, obviously, because now we have 9 Supreme Court justices. Now, over the years, various acts of Congress have altered the number of seats on the Supreme Court from a low of 5 to a high of 10. Yeah, that's smart. Let's have an even number of justices. Shortly after the Civil War, the number of seats on the court was fixed at 9. Today, there's 1 Chief Justice and 8 Associate Justices. Like all federal judges, justices are appointed by the president, are confirmed by the Senate. They typically hold office for life. The salaries of the justices cannot be decreased during their term of office. These restrictions are meant to protect the independence of the judiciary from the political branches of government. Now, what we're talking about is the jurisdiction of the court. What kind of cases do they hear? Okay? Article 3, Section 2 of the Constitution establishes that jurisdiction of the Supreme Court, we're talking about their legal ability to hear a case, has original jurisdiction over certain cases. And original jurisdiction means that the case is tried before them. The first time the case is heard is their original jurisdiction, okay? And those are generally limited to very specific cases that make sense, such as suits between 2 or more states, or cases involving ambassadors or other public ministers. The court otherwise has appellate jurisdiction on other cases that involve points of constitutional federal law, and some examples, for instance, involve federal statutes and so on. So when exercising its appellate jurisdiction, the court does not have to hear a case. Generally speaking, you have to apply for, it's called a writ of certiorari, and you file this writ with the court, and you ask them to please hear your case. And if they grant the writ, they'll hear it, and if they don't, they don't. So in case you're curious, this is all from the Certiorari Act of 1925. Gives the court the discretion to decide whether or not to do so, that is, to hear a case on appeal. In a petition for writ, the party asks the court to review the case. The Supreme Court agrees to hear about 100 to 150 cases of the 7,000 or more that are sent over every single year. So 7,000 cases get submitted to the court to be heard, and the court chooses to hear 100 to 150 of them. So we talked about the fact that, generally speaking, most of the things you hear about the U.S. Supreme Court are them hearing cases on appeal, okay? They decide to hear a case because they think it's important, affects a lot of people, or it's going to clarify some issue of law. They agree to hear the case. They hear the case. Briefs are submitted. Then they issue a ruling, and that opinion then, of course, gets issued, and that's the new law. And, of the 100 to 150 cases that they have every year, some of them are very important, and some of them may or may not affect that many people. But, they do what they do, and that's that. But when someone asks me and says, Steve, the Supreme Court, do they ever sit as a trial court? Do they ever actually conduct trials? Well, I was actually aware of this because I've talked before about how I wrote a book about Douglas Houghton. Douglas Houghton was an explorer in Michigan in the 1830s. He passed away in 1845. And during his lifetime, Michigan became a state. And in 1835, Michigan applied for statehood, but was denied because Ohio wouldn't let us in. It was lobbying on the part of Ohio that helped keep us out. And at the time, there was a strip of land that Toledo was in, and there was a fight over whether that strip of land lay within Michigan's boundaries or Ohio's. And there was a thing called the Toledo War. Won't get into that right now. But let's just say that by the time the dust settled, it was settled that Michigan could become a state if they agreed to give up the Toledo Strip in exchange for the Upper Peninsula of Michigan. Very complicated because, number one, the Upper Peninsula of Michigan, 1/3 of it already did belong to Michigan in terms of that. The other 2/3 wasn't actually owned by the federal government, even according to their own rules, and they kind of had to acquire it in 1841 in an attempt to give it to Michigan in 1837. Again, very complicated and convoluted, but that's how the government did things back then. But as I was doing all the research on this story for a book I wrote about Douglas Houghton called Michigan's Columbus, I came across this curious case of Michigan versus Ohio. Now, most people in the Midwest, when they hear the phrase Michigan versus Ohio, they go, oh, is it October? Because there's always a big football game between Michigan and Ohio, and it's often a big game in the Big Ten, which oddly has more than 10 teams in it now. And there was actually a legal issue that arose between Michigan and Ohio in 1972, and it was settled in 1973. And Michigan sued Ohio. And now, again, you'll recall that original jurisdiction arises in the Supreme Court in lawsuits between states. So when Michigan sues Ohio, and think about it, it makes sense. You don't file that lawsuit in Michigan because that wouldn't be fair to Ohio. You don't file it in Ohio because that wouldn't be fair to Michigan. Who's going to sit and hear a case when the two states are squabbling amongst themselves? Oh, the U.S. Supreme Court will, okay? So Michigan filed a lawsuit with the Supreme Court in 1972 claiming that the boundary between Michigan and Ohio was supposed to go straight to the east. Straight line across the top of Ohio, across the bottom of Michigan, should just go out and be a straight line. And you might go, why does that matter? Well, that line would go out and extend across Lake Erie, which we talked about recently. But Michigan was convinced that actually the straight line should go straight. Ohio said, no, it should actually go up at a 45-degree angle. Now, you might think, again, who cares? Well, it turns out it makes a little bit of a difference. So, case was decided 1972. And by the way, curious, the case caption is Michigan versus Ohio, 410 U.S. 420. And the fact that the U.S. is between the 410 and the 420 indicates that this is, in fact, a Supreme Court case. And the 410 is the volume, 420 is the page number that it's found on, that it begins on. And the Assistant Attorney General of the state of Michigan, Charles Keeley, argued the case. And Assistant Attorney General of Ohio, Charles Rawlings, defended the case. And it's interesting because it says there's a report of the special master. And you might say, wait, do they take witnesses? I mean, do they actually have people come in and swear, take an oath? There's 9 justices up there listening to cases. Well, the interesting thing is that I've mentioned it before about when you have a trial, the judge issues rulings on the law, and a jury decides the facts, unless you're doing a bench trial, in which case the bench, the judge, decides the facts. How does the Supreme Court decide facts without calling witnesses, or do they call witnesses? Well, in this case, apparently, and I couldn't find much information on this, but apparently the Supreme Court actually assigned a special master. And a lot of courts will do that, especially in federal courts, where they want something done at the direction of the court. Someone's acting on behalf of the court, but it's not like a bailiff. It's usually somebody who is trying to look into something or do something or handle a situation for the court. And so the special master investigated the claims of the two parties and came back and issued a report and said, you know something? We're pretty certain that when the border dispute was decided between Michigan and Ohio, the line was expected to be a 45-degree angle. So what happened then was there was some oral arguments afterwards, and Michigan objected to that. And Ohio, of course, liked the ruling of the special master. And the Supreme Court decided to adopt the findings of the special master, and that was that the dotted line was supposed to go to 45. So upon consideration of the report filed November 9th, 1971, by Senior Judge Albert B. Maris, special master. So in other words, the Supreme Court found a senior judge and said, you know, you look into this and make an initial ruling that we will then examine. Upon consideration of the report, exceptions filed thereto, that is, the people who objected to it, and argument thereon, it is now ordered, adjudged, and decreed as follows. 1. The exceptions filed by the state of Michigan to the report and recommendations of the special master are overruled. Darn. 2. The boundary line between the states of Ohio and Michigan in Lake Erie follow a line drawn from the point in Maumee Bay, where the North Cape of that bay was located in 1836, on a course having a bearing north 45 degrees east, measured from a true meridian, passing over the center of the existing circular concrete seawall on Turtle Island. The only thing this affects is a little tiny island called Turtle Island. On the same course through the lake to the point where it intersects the boundary line between the United States and Canada. In 1836, the North Cape of Maumee Bay was located at the point in that bay where a line drawn north 87 degrees, 49 minutes, 44 seconds, east from post 71 on the land boundary line between the states of Ohio and Michigan, intersects a line drawn south 45 degrees west from the center of the existing circular concrete seawall on Turtle Island, both bearings being measured from a true meridian. So all it did was, if you look at a map, you see a dotted line that goes out over Lake Erie. One dotted line goes this way, one dotted line would have gone that way. And if you look at it really, really closely, you'll see the dotted line on one of those cuts right through the middle of an island, who the people of Turtle Island, and I think it's just a house, but there's not many people on Turtle Island, but the people who lived on Turtle Island in 1970 thought they lived in Michigan. 1973, they found out they actually lived in Ohio. I hate when that happens. So, meanwhile, the cost of this suit, including the expenses of the special master, shall be borne by the state of Michigan. So Michigan not only filed the suit and lost, had to pay the costs of the state of Ohio in the process. But the cool thing was that the trial, in essence, was conducted by the Supreme Court. And so, like I said, when it came to actual fact-finding issues and investigation, it doesn't look like they took witnesses or anything like that. They simply had the parties submit evidence. The special master looked at it, weighed it all, and then handed in a report to the bench. And the bench then said to the parties, would you like to file briefs now that you've seen this report coming from the special master? And they said, yes, we would. And they filed their objections and their reports, and the Supreme Court took everything into consideration and picked a winner. And that's what they got to do, because they were sitting as both judge and jury in that case. So it's a fascinating case to some of us, I suppose. But it answers the question, when does the Supreme Court get to actually act as a trial court? And that is one example. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. We're here for a good time, not a long time. So have a good time. The sun can't shine every day.